I'm Floyd Stokes, your instructor for AJ3, Introduction to Corrections at College of the Redwoods. These series of PowerPoint videos are meant to give you an overview of each chapter of the text, but you will still need to thoroughly read each chapter. Today I want to discuss Chapter 4 of our text, which is titled Sentencing. This chapter has 6 learning objectives. 1. Identify the various types of sentences and explain the problems of comparing them in terms of severity. 2. Explain the 2 basic sentencing structures used in the United States. 3. List and explain 3 sentencing practices. 4. List and describe 3 techniques used to reduce the length of a sentence. 5. Give examples of specific measures that evidence-based sentencing suggests judges should follow during the sentencing process. And then finally, 6. Describe 2 types of sentencing injustices. Now let's get started. As the text points out at the beginning of the chapter, one would expect that the more serious the crime, the more severe the penalty. But this is not necessarily the case, and offenders themselves may perceive the severity of punishment very differently. Some offenders may prefer the structure of prison to the greater personal responsibility needed to successfully complete a community-based penalty. Also, race, ethnicity, and gender appear to influence offenders' views about the severity of various punishments. There are 10 types of punishments, not counting execution, of course, that are listed in Table 4.1 on page 57. To begin with, fines, regular probation, intensive supervision probation, electronic monitoring, community service, day reporting, halfway houses, boot camp, jail, and of course, finally, prison. These are not necessarily listed in order of severity, and each will be discussed in greater detail throughout the text. In order to determine the most appropriate sentence type, sentencing judges need information about the crime and the offender. This is accomplished by a probation officer who interviews the convicted offender and collects information regarding the adult offender's criminal record and relevant personal and family data. The probation officer also collects information about the harm or losses suffered by the victim. The probation officer then writes a pre-sentence investigation, or PSI, report and submits it to the sentencing judge. Studies conducted in various states found that sentencing judges followed the probation officer's recommendations in most cases, ranging from 66% to 91%. About half of all states require a pre-sentence investigation in all felony cases. Although the PSI's primary use is to assist judges in determining the most appropriate sentence for a particular offender, it is also helpful to probation officers charged with supervising the offender in the community. It is used by prison officials in the classification and program needs assessment. It is used by parole boards in making release decisions, and it is used for research purposes. A typical PSI will be about 8 to 10 pages, and it will contain the following: personal data, court information, release status, offense information, victim impact, criminal history, offender characteristics, financial information, sentencing options, and finally recommendations. That's a lot. Despite its importance in the process, the use of the PSI at sentencing for felony crimes has declined in many states due to funding cuts and the increased use of determinate sentencing. The two basic sentencing structures in the United States, indeterminate sentencing and determinate sentencing, are what we're going to talk about next. Indeterminate sentencing is a system in which the convicted offender receives a sentence that covers a time range rather than a fixed period. Indeterminate sentences is linked more to rehabilitation and behavioral change while incarcerated, with release determined by a parole board. On the other hand, determinate sentencing is a system in which the convicted offender receives a sentence to a specific time period rather than a time range. Statutory penalties are sentences that may be linked via legislation to specific crimes or to specific classes of felonies or misdemeanors with a minimum and maximum period. Read pages 58 and 59 for more detailed information on these three topics. The three sentencing practices used today are sentencing guidelines, mandatory sentencing, and aggravating/mitigating circumstances. Here are some definitions found in the text. Sentencing guidelines impose a predetermined sentence length based on crime severity and prior criminal history, with the opportunity for the judge to depart from the guidelines when circumstances warrant. Voluntary sentencing guidelines are suggested rather than required guidelines that stipulate a time range for a judge to use when deciding a sentence. Presumptive sentencing guidelines are required rather than suggested guidelines for a judge to use when deciding a sentence. Mandatory sentencing requires a prison sentence for some crimes and some offenders. Truth in sentencing is when the length of time served in a sentence is close to the time imposed by the courts. 3 strikes and you're out laws are laws that authorize or mandate, in some cases, longer periods of incarceration after a certain number of prior convictions or strikes. Aggravating circumstances would be an event or condition that makes an offense more serious than it might otherwise be, and mitigating circumstances would be an event or condition that makes an offense less serious than it might otherwise be. The judge assigned to preside over each criminal case determines the sentence. The range of sentences that can be used by a judge for any criminal case is identified in the state's penal code. Sentencing guidelines can be either voluntary or presumptive. Sentencing practices linked to mandatory sentencing are truth in sentencing and 3 strikes, you're out. Washington was the first state to enact the 3 strikes law in 1993. California followed in 1994. Judges may take aggravating circumstances and mitigating circumstances into consideration in the sentencing decision within sentencing guidelines. In many jurisdictions, judges are required to provide written reasoning for departure from guidelines. Sentence length can be reduced by pretrial jail time, good time, or concurrent sentencing. Here are some key terms. Pretrial jail time. That's time spent in jail either pretrial or after conviction that could be counted toward a convicted offender's sentence. Good time. That's the reduction of days from a sentence as the result of statutory provisions, the offender's good behavior, or extra work done by the offender. Statutory good time is the reduction of days from a sentence, usually given automatically as a prison management tool to relieve overcrowding. Earned good time is good time credits resulting from good behavior or through participation in work or education programs. Meritorious good time is good time credits given to inmates who perform exceptional acts or services such as firefighting or working in emergency conditions. Concurrent sentencing allows an offender convicted of multiple offenses to serve those offenses at the same time. Evidence-based sentencing. This involves the use of scientific research to improve the quality of judicial decision-making when determining sentences and sentencing conditions. Prior to evidence-based sentencing, judges relied on gut instinct, experience, or guidelines set by legislators when deciding an offender's sentence. Findings from evidence-based practices suggest that during the sentencing process, judges should act as a change agent rather than merely enforcing compliance to minimize any negative effect of the court process on the offender. Further, the judge should work to assure that offenders believe they have been treated fairly and should integrate effective treatment programs with other sentencing requirements. Today's sentencing policies do not openly target any specific groups of people, but many changes in sentencing policy have increased the disproportionality of Latinos, Native Americans, and African Americans who were sentenced to prison throughout the country. Two types of sentencing injustice stand out. Sentencing disparity, a type of injustice in which the sentencing policy has the unintended effect of targeting a population group, often a minority group, and resulting in members of that group being disproportionately represented among persons in the correctional system. And wrongful conviction, which is a type of injustice wherein a person is convicted and punished for a crime they did not commit. Okay, to summarize this chapter, sentences range from fines to prison. Ranking sanction severity is difficult due to the perception of the individual. The three sentencing practices in use today are sentencing guidelines, mandatory sentencing, and aggravated/mitigating circumstances. The two basic sentencing structures in the United States are indeterminate and determinate. The techniques to reduce sentence length are pretrial jail time, good time, and concurrent sentencing. Evidence-based sentencing is changing the way judges handle procedures from sentencing to interaction with offenders. The two types of sentencing injustice are sentencing disparity, generally toward minorities, and wrongful convictions. Before I close, be sure to read page 70 of the text that discusses the issue of California's three strikes law. We'll discuss this issue further in class. Well, that's it for now. We'll see you in class.